we're missing one of our people. When Paul gets back, we'll talk about the minutes. Has anyone had a chance to look over the minutes? Has anyone seen something that they think should be corrected? You were emailed the minutes. So you let me know. Then thank you all for being here. Why don't we go ahead and get started with Taylor Murray from the Department of Revenue. Welcome. Thanks for being here.
Hey, good morning, Madam Chair, members of the committee. So my name is Taylor Murray. I'm with the Office of Policy and Research for the Department of Revenue. First off, I'd like to thank the committee for consideration of these regulations. So today we're looking at 4 proposed changes. The first, the department proposes revoking KR 922214, 922223, and 922232. So when these regulations were made effective, renters were eligible for the homestead refund program. They're no longer eligible. These regulations deal with items specific to renters. And again, that's 922214, 3223. And I can take questions on those 3, or I can move on to the next one, whatever you'd prefer.
Representative Sawyer.
I'm just curious. We got rid of that in like 2012. I just wondered why it's taken this long to get rid of the rules and regs. If there's
that's correct, Representative. That was effective. I think 2013 was the first year that renters weren't eligible. And this is just a cleanup process we're looking at. So we're going through regulations. I think we saw some inheritance regs earlier in the year. It's just a kind of a cleanup process for us.
Senator Warren.
Thank you, Madam Chair, and thank you for being here this morning. Could you tell me the number that you're talking about? The KAR number?
Yes, that's KR 922214, 23, and 32. If you want me to zero in on a specific regulation, I can do that.
So which one is the one you're talking about that renters are no longer eligible for? Is it the homestead? Is that what you're talking about?
Yes, I'm sorry too. Maybe I should have introduced a little more. Yeah, this is
just go through them one by one for a minute. That'd be great.
I can do that. Yes.
That's all right.
So
thank you.
Yes, we're talking here about the homestead refund program, which as you may be familiar with, it's a tax refund, or it's not really a tax refund, but it's a refund for your property taxes that are paid. 922214. It's a definition of, so the regulation is called rent constituting property taxes accrued services. A claimant shall not include services rendered within gross rent as an equivalent of cash. This is because the statute used to use the term gross rent when renters were eligible. So the regulation is no longer needed because the definition is no longer used in statute. Does that, or would you like me to start?
Well, I don't have any questions. If you just could go through them. And
okay.
Thank you.
922223, that talks about how you compute the amount of the claimant receives. If they're renting, so they're the tenant and they're owning a home for the entire year. So currently you have to own the home for the entire year to qualify. And then 922232, this is another regulation that relates to the definition of gross rent, which again is a term that's not used anymore in the statutes. So, and I apologize again, I'm backing up here, but right now you look at the property taxes directly paid. Previously, when renters were included, they would look at the rent those people paid, and then they would assign a percentage of that and say that was effectively, right, the property taxes paid. So as a renter, you're paying rent, then some percentage of that is then used by your landlord to pay property taxes. So that's how it used to work, as Representative Sawyer said, back, pre-2012. Currently, only homeowners are eligible.
So in 2012, the legislature made a change that renters would no longer be eligible for a refund for the percentage of their rent that was property taxes? Or could you explain that a little bit more clearly if that's not?
Yeah, yes, that's correct. In 2012, a bill passed. Renters were no longer part of the program, so it was limited only to homeowners.
That was before my time in the legislature, but that's an interesting change. Thank you.
Senator Francisco.
Thank you, Madam Chair, and thank you for being here. My understanding is this is part of a overall tax bill change that had been promoted. So it wasn't done individually, it was done as part of a series of changes.
I believe that's correct. Now, that was before my time too. If you'd like, I can look into that.
I was there.
Okay.
And, I'm still disturbed that the legislature did make this change because as a landlord, I know that I use some of my tenants' rent to pay property taxes. And since we have this homestead program for tax relief for property taxes, some of them were no longer able to get that help. Thank you.
Madam Chair,
Senator Tyson. Oh, yeah, that's fine. Senator Faust-Godot.
the legislature too at that time, and I just wanted to say I voted against that measure because renters do, in fact, their rent. So anyway, I just wanted to chime in and say that. Thank you.
Thank you, Senator. Is there anything else? Senator Tyson. Thank you, Madam Chairman. This is probably a question for the revisers. Thank you for getting this done finally. But my question is for constituents and others, it's very confusing. We passed the law in 2012. The rules and regs still stand as such. Which one supersedes the other?
Thank you, Madam Chair. Jenna Meyer, Riser, Statutes Office, and statutes have precedent over rules and regulations. So if there's ever a conflict, the statute would supersede.
So even though they weren't finished removing them, it still had the same effect.
If there would be an attempt to enforce the provisions of a rules and regulations that was prohibited by statute, it would be null.
Wonderful. Thank you, Madam Chairman. Senator Francisco.
Thank you, Madam Chair. So my understanding is these are ways that the gross rent was determined. So in fact, if there's no determination of gross rent, none of these would apply. So it didn't really matter that it hadn't been repealed. I'm glad it's being repealed because it's just taking up ink and paper. But beyond that, it would have had no effect on any individual because they could not apply for this homestead tax relief.
I believe that is correct. Yes.
Thank you.
All right. Are there any other questions? Okay, thank you. Did you have anything else?
I do have the amendment. Yes, I apologize, Madam Chair. So second, the department proposes amending KAR 922217. Now, this is the regulation that spells out the documentation that must be attached if somebody's making a claim on another person's behalf as their guardian, conservator, or their attorney in fact. So currently, the regulation asks for a recorded power of attorney, which is not required by the statute. And it's not enforced. There's really no procedure to check whether the power of attorney that's provided is recorded or not. So the proposed amendment deletes that requirement, just deletes that from the regulation, and also deletes a reference to an obsolete form that hasn't been used for several years. And again, that is 922217.
All right, any questions on this?
Yes, Representative Carmichael, I do have a question.
Yes, Representative Carmichael.
Thank you. I'll be honest with you. I thought all of these were revocations, and I just took a look at 92, 22, 17, and you said it does away with the requirement that it be recorded, but they still have to attach an attested copy of the court order granting the conservatorship. Is that correct?
Yes, that's correct. The changes, so the regulation covers guardianship, conservatorship, or power of attorney. The changes we're making only apply to the power of attorney portion.
Okay, if it's a guardian or conservator, they must attach an attested copy of a court order. But if it's a simple power of attorney, do they attach anything?
Yes, so they'll still attach the power of attorney. There's just no requirement that it be recorded as, say, a deed would be recorded. So you can have a power of attorney on file with, say, like the Register of Deeds. There's really no requirement for that in this context. So we're proposing removing that from the regulation.
And so if I hold a power of attorney for my mother and I keep it in my bottom desk drawer, if I need to file a claim on her behalf, I just make a photocopy of what I found in my desk drawer and send it in.
I think I'm not sure if I am able to answer that question without seeing the power of, without having everything. Generally, though, we're just asking for a valid power of attorney attached to the form.
Right. And so what is it you would need to see in order to know whether or not my filing would or would not be accepted under this new regulation, other than a copy of the power of attorney that says John Carmichael's granted power of attorney or attorney in fact for Joe Carmichael and this whatever day and a notary's attestation? Is there some other requirement that I would have to send in?
No, I should clarify. What is happening now, the power of attorney that's being provided, there's no change there. So this regulation will not result in any change of practice or requirements. All that we are looking to do is, with that portion of the change, to delete that recording requirement, which isn't required by statute and is not being checked or really enforced.
Well, I agree with you. This makes good sense, Madam Chair. Thank you.
All right. Thank you. And I don't see any other questions, so you may continue.
Okay, that is
went backwards. Okay, that's why I thought.
Yes, and I apologize. I just thought it'd be easier to deal with the revocations before the amendments, and maybe that was a mistake. But I'll stand for any other questions.
Things the way we've been given them. So
I apologize, and I also I apologize for a little not enough preface on the homestead portion of the revocations. But
thank you. Appreciate that.
Okay, thank you, Madam Chair, members of the committee,
for being here. I think we've heard. We know that Senator McGinn's online, and then Representative Carmichael and Senator Fausto. All right. If you just wait she's still here. Maybe we can go over the minutes now and vote on them. Does anyone have any changes or corrections?
Thank you, Madam Chair. I move we approve the minutes from our October 2023 meeting as presented.
Do we have a second anywhere?
Second.
Representative Sawyer, we have a motion from Senator Warren and a second from Representative Sawyer. All those in favor, aye. Opposed, same sign. Okay, minutes are passed. Thank you, everyone. We will now move on to State Board of Examiners of Optometry.
Good morning.
Committee.
I am Jan Murray. I'm the executive officer of the Board of Optometry. And today we're looking at adding a regulation to update the biannual renewal. The biannual renewal, according to the records that I've been before me, started back in like 2004 when the first one was passed, and it was based on birth month. If you were born between January and June, you renewed in the odd years, and June through July, you were born in the even years, and it was kind of got confusing as to who was renewing when and what. And so in 2015, we did away with it altogether, and everybody just renewed for 2 years, period. But that kind of resulted in revenue being higher one year and lower in the next year, and it was kind of hard to explain in budget committees why my revenue one year was as high and then low. And it's about 50 more renewing in one year versus the other year, which is roughly about $27,000. And when you're looking at a small agency like mine, that's a lot of money. So this one is to go back to, if you're an odd license number, you renew in the odd years. And if you're an even license number, you renew in the even years. And hopefully that will cut down on some of the confusion, which means the new ones, half of them will renew for 1 year and the other half will renew for will renew for 2 years, depending on if their license is even and odd. But I would like to point out that when we were working on this reg, we had it starting in 2024, but that was based on me getting a new licensing program in 2024. But it looks like now I will not be getting that until 2025. And so we would not be starting this until 2025 when I got the new licensing program that would be, would work with Senate Bill 66 for the electronic verification. So, and when I talked to the AG's office about it, they're like, well, you just don't start enforcing it until 2025. But that's my reg in a nutshell.
Okay. Are there any questions? Representative Wagner.
Thank you, Madam Chairman. Senate Bill 66, what did that state and what was the relevance to this?
It stated that I don't have probably the quite terminology for, but basically electronic verification, that somebody could log on to the system and get an electronic verification or license for the individual instead of it being, right now it's done by paper. It's,
if I may, is that something directly aimed at the Board of Optometry,
no,
or is
it's
that was for everybody? Okay.
It's everybody. And I'm currently working with OITS, who's got a contract with Acela to do the licensing program that a lot of small agencies are going to. And I currently don't start working on that until August of 2024 to go live March of 2025.
Again, just, and I used to be on General Government Budget Committee, so this is, but so how many licensees do you have?
Roughly 730 right now.
Okay. And what is the charge for a biannual?
Biannual is $550
$550
for 2 years.
Okay. Thank you.
Are there any other questions?
Madam Chair, Representative Carmichael.
Representative Carmichael, go ahead.
I just wanted to mention, not only for our conferee, but also for the committee's benefit, that I would be with you there this morning, but for an appointment with my optometrist this afternoon at 2:00. So I thought it was somewhat ironic. I will report to him that the agency is doing fine work to regulate his profession. Thank you.
Okay. Well, that was not really a question. That was kind of a comment. My only question is, and I'm trying to ask this of everyone, if you could tell me how much money you have in unencumbered funds.
I was not expecting that a question. Right now, well, we have a litigation fund, and right now that's about 90,000, because I just had 90,000 transferred back over to the fee fund. So the fee fund's probably got 100,000 unencumbered.
Okay. All right.
Roughly. And if you want exact numbers, I can get them to you later.
That's wonderful. Thank you. All right. Thank you for being here. Appreciate it. Now we'll move on to the Board of Mortuary Arts. That's why you're so quiet in the hallway. Welcome to committee.
Thank you, Madam Chair. We're taking a look at an amendment to 6323 And basically what it is it's the responsibilities of a funeral director. Pretty much in a nutshell for this, the amendment would make it so a Kansas licensed funeral director can be in charge of more than one establishment. Right now, is the way the regulation reads, they are unable to do so. A Kansas licensed funeral director can be in charge of one establishment at this time and as many branch establishments as they want to be. But however, they cannot be in charge of two more than one establishment too. So that's the basic change that we're looking for. And with that, I'll stand for questions.
Senator Warren.
Thank you, Madam Chair. Was this a change that you're proposing pursuant to a statute that was passed this last session?
No, it's not.
What's the impetus then for the change?
Basically, the impetus for the change is that in populous areas such as where we're in Topeka, Kansas City, Wichita, and things like that, there are a larger number of funeral directors that are available. When we get out in our western states, I can take Dodge City, Garden City, things like that into an account. There are fewer funeral directors to go around. And therefore, one funeral director may own more than one establishment, but they still cannot be in charge of what they own. They have to employ somebody to be in charge of that establishment.
So this is an industry-driven change?
Yes. As a matter of fact, it was brought to our attention by the Kansas Funeral Directors Association, and they're more of a, of course, we're the regulatory board. They're more of a membership driven agency, and this is something that they are seeing from their western state and from our western counterparts here.
Thank you for providing that context for the proposed amendment. Thank you.
Senator Tyson.
Thank you, Madam Chairman. I agree with Senator Warren. This is a substantial change just to be making through rules and regs. And I'm assuming you have the authority to do it, but this to me, and I'm not saying against or for, just needs to be something that goes through the legislature, this massive of a change. It's similar to the physician's assistants not being under doctors anymore. I think it needs some debate. It's, as I say, a pretty substantial change. I do agree there's some issues with the funeral directors. I think some other stuff that needs to be looked at also. The time it is taking you guys to receive certificates from KDHE and how they're handling death certificates now. I understand they've changed the policy and made it more difficult to get those certificates. So I know that's not related to this, but I do know that there's other issues going on with the industry that are harming your ability to keep the cost down and be effective. So if we can help in that manner, maybe get both of these through, that would be great. Thank you, Madam Chairman.
All right. Representative Wagner.
Since we have some time, I mean, of course, you see a lot of consolidation in the funeral home industry. You know, like where instead of family-owned homes or independent funeral homes, now they're all owned by a couple of different companies, at least are one regional company. So currently, I mean, just the import of this, that even if somebody has like 5 funeral homes in their chain, they have to have a funeral director in charge of each individual establishment, and the change is that would no longer be required.
No, what happens is I'll throw out an example. I think that not necessarily would it be like a conglomerate or a chain. Let's say that XYZ funeral home existed in I'm going to use Lawrence, and ABC funeral home existed in Topeka. They are both establishments by number. Then one buys the other. It is not a branch establishment. So therefore, you have to have a funeral director in charge you do have to have a funeral director in charge for each establishment and branch establishment, but the same funeral director that can be in charge of, if it was a branch, the same funeral director can be in charge of that branch. He just could not be in charge of that branch or that main establishment. Does that make sense? I'm sorry, maybe I muddied that a little bit for you.
Yeah, I'm a little, so if it's the same ownership,
Same ownership.
you currently they can like, and I'll just use like out in my area, you know, like out in Lyons, Kansas, that like they own the Ellsworth Funeral Home now or something like that. So the person who owns who's the main owner there at Lyons, they have to have somebody separate actually employed in Ellsworth to be the director.
If it is an establishment.
If it is an establishment, and
That's
it's
correct.
the definition of an establishment, it's separate.
The basic definition, the main definition would be that an establishment has a prep room, showroom, and everything else like that. A branch establishment does not have to have a preparation room or a showroom.
Okay, that's helpful. And then also, I'm just to be a funeral director. Is there some special licensing or fee, or how hard is it for, you know, a funeral home company to have multiple directors? Is that a licensing question, or just, you know, is that just strictly employer designates you as a director, you're an assistant director, you're whatever?
No, you have to have 60 hours of schooling, and there's specific hours that are required by the board to have that. You need to serve a year's apprenticeship upon proof of your schooling.
So there is a lot there. The and currently in Kansas, how many licensed funeral directors do we have?
Well, probably close to around 1,900.
See,
it's 18 something. I can.
That's okay. And one final question, if I can, Madam Chairman, and so there is no, a director may be in charge and have personal supervision of more than one funeral establishment. So that could be 2, that could be 200. I mean, is that correct? There is no outer limit to this?
That is correct.
Okay.
Senator Francisco.
Thank you, Madam Chair. And following up on the concern or question from Representative Wagner, was there any discussion of having a maximum number?
No, there was not. There isn't, how should I say, I was trying to think how to say that. There wouldn't be a large number that you could be charge of, if that makes sense. That it just doesn't work that way, because there's a majority that are branches of an establishment. I can't imagine a large groundswell for having, 20 establishments. It's more of a location thing where there might be 2 establishments that are nearby that individual may own, but cannot be in charge of both.
So I appreciate that concern, but especially because the director does not need to be present. You might talk with your members about would it make any sense to say, but no more than 10, and then just go on with the world and not have us worry that you're thinking about 200.
Okay.
I believe we have someone here from the constituent of mortuary arts. Can you come up and introduce yourself and answer some of these questions for the committee, if you would? Thanks for being here.
I'm Pam Scott. I'm Executive Director of the Kansas Funeral Directors Association. We represent most of the funeral homes in the state of Kansas. We're the one that asked for this, mainly because in Western Kansas, you're having a harder time getting people to move there there's a real shortage out there of funeral directors. And, the problem solves sometimes when you have a branch, one funeral home, like up in the northwest part of the state, you may have one person who owns a number of funeral homes. To encourage funeral directors to move out there, sometimes they'll give them a slight ownership interest in the funeral home. And you cannot have a branch establishment unless the ownership is totally the same. Therefore, the branch option does not work. We have some funeral homes probably out in western Kansas that have, 3 or 4 branches. But the point is they could not get enough funeral directors out there to cover all the funeral establishments that they own. I don't think there's any situation where the ownership's so much different throughout the state. There's not anyone that probably owns 10 funeral homes in the state of Kansas. And so they would not have the same employee as the funeral director in charge of 10 establishments. And but there is a real shortage out there. This is something our members asked for, so they wouldn't have to go hire or try to hire. Sometimes they can't find anyone to hire another funeral director to be in charge of an establishment in western Kansas. It's not really a problem in the large cities at all, but it is when you get out west. There's fewer and fewer funeral homes, so much consolidation out there, and it's hard to get people that want to move out there and be funeral directors.
Senator Tyson, and then Senator Warren.
Thank you, Madam Chairman. Thank you. I guess this might be for the revisers too, or research. I'd like some history as to why this rule and reg exists, why it was limited. Was it a business decision or was it something? Because I'm looking at the statute and I just don't see the correlation. So I'd like to know the history. And it does seem like an aggressive change through rules and regs. I have a grave concern when we start legislating through rules and regs.
Well, actually, the rules and regs regulate. The statute does not put any limitation whatsoever on how many funeral. So if you didn't have the reg, you can have as many as, a funeral director in charge of as many funeral homes as you want. But I've been doing this for 32 years. And it predates me by quite a bit. So it's just always been there. I don't know the reasoning before that the Board of Mortuary Arts had back whenever it was drafted. But, right now the statute does not put any limitations on it whatsoever. There's not really I don't think there's a problem of there being too many.
Thank you, Madam Chairman. I know that the statute doesn't put any limits. I see that the rules and regs do. I just want to know the history. It seems like somebody put it on to keep competition down. And maybe this is a great thing. I just know that it's a fairly large change again through rules and regulations. Thank you, Madam Chairman.
Senator Warren.
Thank you, Madam Chairman. Thank you for being present here today. Question for the industry. Was there discussion amongst your members about this change? And if there was it unanimous? Because we've heard, the western part of the state versus the more populated areas of the state. Was it unanimous among the members or pretty close?
Pretty close. We went about a year ago. We made some other changes to the law. Last session concerning allowing, on the apprenticeship, allowing apprenticeships to be served 6 months prior to going to mortuary science school and 6 months afterwards, trying to help people get into the business. And so we went and did a road show across the state and also talked about the funeral director in charge. And I haven't heard, we have a magazine we send out emails, and not one person has shown any opposition to that whatsoever.
Thank you for providing that context. That's helpful to know. Thank you, Madam Chair.
Representative Wagner.
Again, thank you, Madam Chairman. Since we have time, so how many, I mean, since you're from the industry, currently in the state of Kansas, how many branches are there in the Kansas and how many funeral establishments are there? What's kind of the raw numbers?
Well, he'd be more suited.
I don't have it broken down into the aspect of individual, but if you took establishments, branch establishments, and crematories, we currently license 378 in the state of Kansas.
Okay. Okay, that's fair enough. Thank you.
Senator Tyson.
Thank you, Madam Chairman. Off topic, but are you doing anything about the KDHE limiting the number? You know exactly what I'm talking about.
Yes, that's taken
It's a
up a
big
lot of
issue.
my time.
Yeah.
Earlier this month, there were some problems. The main problem is the Postal Service, and I don't know how anyone solves Postal Service, but KDHE had for a time only allowed you can mail in your request for the family's request for death certificates. It can go through the mail to KDHE and go back to the funeral home. There's also an option where you can order online and pay for it online, and you can choose an option of someone using UPS or something like that. But since there were, and it's just been like there was like a 6 weeks period where it really got bad, where it was taking in some cases a month for death certificates to get back through the mail. And to try to help, the KDA Office Vital Statistics slowed down, or they changed the website so you could only order 6, because apparently the envelopes that you can order 6 in move through the Postal Service a lot faster than if you have to use a larger envelopes to put over 6. So they thought they were helping by putting 6 down, but it kind of created a big problem. But we got them to change the policy back to where it was. But that doesn't solve the post office problem, and I don't know how you solve the problem with the postal service. I mean, it's not just us that are having problems. I know everyone has problems getting mail out there. I wish I had the answer to that, but it's not like the post office though can tell what's. I mean, I'm not supporting the post office because it makes us angry, but how do you they don't know which envelopes have death certificates in them that don't have death certificates in it.
Yes, thank you. But I'm glad to hear the key in there was KDHE did change the limits then.
Yeah, we got them to pretty quick to switch around once they knew that was, they thought they were helping, but it actually incurred a bigger problem than.
Well, I'm very glad they were responsive and receptive to the input, because that was a major deal. I was hearing about the cost increase.
It won't solve the whole problem though, but yeah.
No, the post office, I won't even touch that. Thank you, Madam Chairman.
You don't want that hot potato? Are there any other questions?
Madam Chair, Representative Carmichael.
Yes, Representative Carmichael.
Thank you, and I apologize. I can't find my raise my hand button this morning. I don't know why, but I appreciate your courtesy in accommodating me. For our conferees, I want to make sure that I understand this. Under present law, if there is joint ownership of a facility and there is no preparation or viewing at the remote branch, then one funeral director can be, quote unquote, in charge of both establishments. Is that correct?
That's kind of, I'm not sure what the question is.
Well, a branch establishment doesn't have to have a preparation room, or necessarily a selection room. Viewing is fine. That is okay. If it is an establishment and a branch establishment that has the same ownership, a funeral director can be in charge of both of them. Does that help?
I think so. But if there's going to be preparation, i.e. embalming typically, is there going does there have to be one person in charge for each facility, or can one person presently be in charge of multiple branches?
One person can be in charge of multiple branches at this time.
And does that require a common ownership, or at present, could I just start a practice of being funeral director in charge here in my back bedroom and supervise multiple branches or establishments under the present reg?
The establishment and the branch establishment both have to have the same ownership.
Okay. And presently, can one funeral director act as funeral director in charge of multiple branch establishments so long as there is a common ownership?
Yes.
Okay. Under this regulation, I think it would do away with the requirement for common ownership.
Nowhere in the reg does it state that.
Meaning that now there would not have to be common ownership, that I could set up a funeral director in charge business here in my back bedroom, and I could be responsible for 100 of the 300 and some odd established facilities in Kansas. Would that be correct?
That I cannot answer. Because I don't see how
I mean, I guess technically you could have them all branches on one owner and do the same thing. But
wouldn't they have to have common ownership presently in order to be a branch?
yes,
Presently?
they do.
But under this regulation, you could have multiple ownerships and one funeral director in charge being responsible for 20 or 30 or 50 or 100 facilities under multiple ownerships, and could do it all from their back bedroom, I think.
But what owners are going to allow that to happen? The owners, the whole point in a funeral director in charge is that person is responsible for the establishment. They take responsibility over everything that happens there. Yeah, sure, maybe it could happen, but you're not going to have it.
And to make it even worse, the regulation specifically says that the funeral director in charge never has to even be there. I never, ever, if I set up this new business of mine in my back bedroom as funeral director in charge, I don't even have to ever go set foot in any of the establishments that I'm responsible for. I just need to be willing to sign my name on the line and take some payment from the owner for it. I think that's how this is going to work. Am I wrong?
Yeah, you're wrong. It would never happen. It would never happen that way. I guess it possibly could, but I guess right now no funeral director in the whole state of Kansas would have to be present at a funeral home, and that doesn't occur.
A funeral director, but not the funeral director in charge. The funeral director in charge under this reg doesn't ever have to even set foot in the county, do they?
Well, I guess a funeral director in charge right now doesn't have to do that either.
And I think that's probably a problem right now, but now we're making it absolutely explicit that we can create a situation now with funeral directors somewhat similar to what we've dealt with on various mid-level practices in the medical profession. And I know you all feel like this isn't going to happen, but we have an increasing trend toward corporate ownership, if you will, of funeral facilities with one company, and I could name the name of the company here in Wichita that's acquired multiple, I believe, facilities. And I think we're opening the door to making this funeral director in charge just a pencil whipping operation with no requirement for that person to have ever even set foot in multiple facilities that they may be responsible for all over the state. Yeah, I've got concerns about this regulation, not because, as a practical matter, what you think will be the effect, but rather what is permitted under this regulation, I think would be a very undesirable effect, that we could find one person sitting in their bedroom in Wichita, Kansas, being the funeral director in charge of multiple facilities all over the state and never have to even set foot in one of them. And I'm concerned about that. Thank you, Madam Chair.
Yes.
I guess one of my points there is the person who is actually, there still has to be funeral directors and embalmers at every facility, who is planning, arranging a funeral, embalming a body. There are still funeral directors doing that work. And usually the case is that, especially on Western Kansas, you never know who's going to have to go where, but they're all licensed. We're not in a situation where unlicensed individuals are going to be serving families. It just might be the person that has responsibility over that funeral home. You have to have someone who is in charge of the funeral home that is responsible for all those employees. And I think we're getting away from the fact that there's still funeral directors doing the work out there.
Well, if the work is still being done by licensed funeral directors, they're doing the embalming and etc. Why do we need a funeral director in charge at all? Why don't we get rid of this layer of expense to your members and just let funeral directors go from facility to facility practicing their trade? Why do we need somebody in charge of each facility then?
Well, maybe we don't. In reality, it without it still works. It's just for the government to regulate, they need someone to go to that says that, to say that facility maybe didn't follow the law. It may not be actually serving the public. It might be, doing OSHA requirements or pre-need trust and such. But the reality is that in Western Kansas, may have two funeral homes. They may be separate entities, but there's one person really doing the work because they may only have 20 calls a year. And they can't afford to hire two funeral directors for one to be in charge. And that's just the reality out in Western Kansas.
Does the agency license the actual facilities?
Yes, we do.
And so if there's, and in fact, I know you have an inspector, I believe Mr. Kelly is on his horse probably yet today, riding the circuit inspecting these facilities.
That is correct.
Because it's snowing, and I'm sure Mike likes to ride his horse in the snow. But seriously, if you've already got licensing authority and you license the individual places, if the inspector comes in and finds that there's unhealthy and unsanitary or OSHA violations or whatever, presumably you can yank the license of the facility, whether it has a managing funeral director or funeral director in charge or not. So why do you even need one? I actually think you do need one, but if you need one, I think you probably need one that has at least set foot in the facility. So that's my confusion is, why do you even have funeral directors in charge if they don't ever have to show up for work?
Well, the funeral director in charge is ultimately the person that's responsible for the establishment or the branch establishment. So they're the one that then therefore would answer to the board.
And the individual funeral director practicing there is not answerable to the board?
No, they are as well.
Okay. Well, I'm hopeful that we can have, for once in my 6 or 7 years, a 1-hour meeting. I share the concerns of a number of other members. I'm not sure that this has been given proper consideration, and I know it's addressed to a specific and serious problem about the lack of funeral directors in rural parts of the state. But I think we may be opening the door too broad. And of course, as some of you know, I share that opinion about mid-levels in other professions as well. Thank you, Madam Chair. I hope in our report we'll at least make note of our concerns about this arrangement. And I think it's concerning. The funeral director in charge never even has to set foot in the facility, let alone even the county where they're responsible for providing these services. I don't think that's wise. Thank you.
Any other comments or considerations? I think maybe by giving it some sort of tweak, putting in there that the funeral director does have to go to each funeral home so many times a year. I don't know what that would be. I know, for example, in Hayes, we have one person that owns two different funeral homes. And I know that I'm not sure whether he's hired someone else. I'm sure he has to help with one, but it's a lot for Western Kansas for sure. So I think you need to look into this and see what you need to tweak to make it a little less free form, or come to us for legislation. Gosh, that's a great idea. But anyway, I just think you could do a little bit better. Okay.
Thank you, Madam Chair.
All right. Anyone else? Okay, then you're off the hot seat for a little while. That's all of the testimony we have. Let's move on to committee discussion and comments on proposed rules and regs. We just heard Representative Carmichael's concerns, and I hope you've got that in the comments and discussion. Jill Shelley from KLRD is shaking her head. Yes, she has it on there, so she'll tell us in a few minutes. Is there anything else that we wanted to bring up on these rules and regs? Senator Tyson.
Madam Chairman, we really have no authority to stop it unless we introduce legislation. Do they plan to continue forward or take your suggestion as to reconsideration on the current language?
Could you please come back up, introduce yourself again?
Yes, Madam Chair. J.W. Carey, Kansas State Board of Mortuary Arts. I will take this back to the board. We are in public comment period. We do not have a official hearing set until the 11th of January. So I can take this criticism back to the board and see what they say.
That would be wonderful. And if you'd report back to us, we'd appreciate that. Senator Francisco.
So I'm hoping we can be specific about what changes we would want to see. Personally, I understand that the licensed funeral director would not need to be present at the funeral establishment to conduct personal supervision, but must visit the establishment a number of times. I think the chair was suggesting that. And then I think I would like to see it say supervision of more than one, but no fewer, but more than one, but no more than like 10, or have that discussion about what could ever be a possibility, because I think that could put some lid on concerns about how many individuals are going to be overseen in the back bedroom of Representative Carmichael.
That's my bigger concern in this. Quick question. Is the funeral director also the embalmer?
No,
Okay,
no.
so you have to hire different people to be the embalming.
A majority of our licensees across the state, I should say a majority, hold both licenses. They are funeral directors and embalmers. They're two separate licenses. We do have funeral director onlys. We also have an assistant funeral director. And the assistant funeral director is basically an individual that acts under the supervision of a licensed funeral director.
Thank you. All right, are there any other comments or questions, discussion on anything else that we've heard? I have just a couple things I wanted to bring up quickly. People have been contacting me. Number one, there's a woman in Hayes that wants to do sugaring, and the Board of Cosmetology is saying that she can't. And there is currently, I understand there's some litigation to help her be able to have this position because she doesn't use any electrical equipment or anything else. This is sugar. I just read it. I just wanted to make sure that the Board of Cosmetology, if they're paying attention at all, one, you're going to get sued and you're going to lose. And two, if everything gets bogged up, I have legislation to add sugaring to the threading exemption in the cosmetology area. So I think there's a lot of, I know I have kind of a normal dislike for the Board of Cosmetology since they have so much money and don't do anything with it. I think this would be a good thing just to go ahead and do this before we have to, you have to spend a lot of money on litigation or make this young woman spend a lot of money on litigation, as well as you'd have to dig into your $1 million of unencumbered funds to pay for the legislation. Representative Wagner.
This may be a male question, but what is sugaring? What is that? What is that?
Sugaring removes hair. It's a type of, it's sugar. I want to say lemon juice. What? And water. It's yeah. It's kind of like threading. They're not using specialized equipment. They're simply trying to help a lot of us who have, male or female, more hair than they want. But I would like to alert them that I think that they're in trouble, and they could fix this rather quickly.
Madam Chair,
Yes, Senator Faust-Cadeau.
so do you plan to have the Kansas Cosmetology Board, are they coming before this joint committee anytime soon?
I would like them to come before the committee and the next time we meet, but there's so much that they can't talk about it because they're in litigation.
Mhm.
So,
And the reason I asked, Madam Chair, I have had a few constituents contact me about tattooing, about a tattooing school, and some of the barriers they are dealing with. So, so you think they will come before us in our next meeting or the meeting afterwards?
I would like to extend an invitation. Not much they can talk about the sugaring issue, but
Just some other general issues. Thank you.
thank you. Senator Francisco.
Thank you, Madam Chair. Appreciated your comment, and then was hoping that maybe someone from the Kansas Department of Health and Environment might be listening. And if so, I absolutely believe the story about the size of the envelopes. But it seems to me you could order whatever number that you needed, and they could put 6 in an envelope until they met the number that was requested, and they could all go separately and would still arrive at the same time. There is a limit to the size that now post offices are processing, but it seems that's a really easy solution as opposed to limiting the number. They know. They just put 6 in an envelope and send it on. Thank you.
You're welcome. Senator Tyson.
Thank you, Madam Chairman. That was the issue. The limit of 6 in an envelope increased the cost. Because of that, it was forcing to have more envelopes and increasing, if I understood correctly.
And larger.
That it was increasing the cost because it would take multiple envelopes, what they would normally get shipped into one envelope. And I My husband and I had an experience. We had a very important letter that went in the mail. It sat for 10 days in the Kansas City post office. No, we do know that the post office is the problem, but the constituents that contacted me were concerned about the cost from KDHE and the multiple envelopes, and that they couldn't get more than 6 in an envelope. So thankfully, KDHE did remove that requirement, and they are putting as many as they request in one envelope. Okay, good to know. There's another issue that I know I don't have a forum so much, but there is a surgery center in Leawood that is allowing anesthesia assistants to work in their surgery center because the Kansas nurse anesthetists have talked to them. They don't. KDHE says they're drawing up a report. It could take a year for the report to be done, and they are employing people that we specifically have not been able to pass a anesthesia assistant as being able to practice in the state of Kansas. And so I thought you all might be interested that we have more problems going on. They've decided that they can do what they want to. And so talking to KDHE, talking to the Board of Healing Arts, we've got a problem and it needs to be fixed. So I wanted to give you a heads up. Is there anything else that will come before the committee that anyone would like to have or say? If not, then this meeting is adjourned.